basic legal position of our law firm, Fry & Associates, representing the widow, Mrs. Nikki Araguz, is the following. The 1990 case of Littleton v. Prang has been overruled by operation of law. The 2009 Texas Family Code, Section 2.005, recognizes sex change for the purposes of marriage in Texas. That is our basic legal position.
Our position is it's not a same-sex marriage, that the law recognizes Nikki Araguz as a female, so that was a marriage between a man and a woman.
But again, for your answer, Darryl, the question will always be from the other side, is that from Nikki saying that the final surgery happened in October, you had been married 2 months prior, is that correct?
Correct.
2 months prior?
Correct.
They will still argue that first line of the marriage code that says a man cannot marry a man. That will still be their answer regardless of what you say here.
I understand, and so I'll just take the opportunity to respond to that now. That's in my more detail than my motion to dismiss for lack of subject matter jurisdiction. The fact that the Family Code, Section 2.005BA, specifically delineates sex change as a valid document for a county clerk to issue a marriage license. Brings in the fact that you can be informally married in the state of Texas between a man and a woman if they agree to be married, hold themselves out to be married, represent to others that they're married. I'm sorry?
And they live together.
And they live together so we've listed those elements of informal marriage which is recognized. And so our position is she's recognized as a female under the code. He's obviously a man. They had a valid informal marriage in the state of Texas. Every marriage in the state of Texas is deemed valid until proven otherwise, and that's our response to that particular argument.
So this new law took effect September the 1st. So our argument, and it's delineated in our papers, is
September 1st, 2009.
Correct, that she had a legal informal marriage. When you hear the word informal, that's the new state law word for the old state law word, which was common law. She has a legal informal marriage since September the 2nd, 2009, up until the day her husband was taken. It really shouldn't be a test case because the legislature spoke. One of the attachments to the motion to dismiss for lack of jurisdiction is the legislative history of this law that was enacted in the 2009 legislative session.
First few pages.
Yes, the first 2 pages. We just didn't copy the whole thing. You can get it on the internet, but it's the entire calendar. It shows who introduced the bill, when it was introduced, that it went through a House committee, that it was voted out of the House committee without opposition, and then floor discussion, and it was amended, and when it was amended, they went from 4 categories to the current 19. If you read all these different categories, it's good government type stuff. And I know that one of the reporters is working on an article on this very bill and how it's passed. It'll probably pop up in the next day or 2. But it's all good government type stuff, those 19 issues. Okay, then the amendment was passed. It went for a 3rd reading. It went on the House consent calendar, which means uncontested. So it was uncontested, and it was voted unanimously on the uncontested docket. Warren Chisholm even voted for it. Then it went to the Senate. Wentworth had it with all the amended language. It went through a Senate committee hearing and went through the whole schmeal in the Senate with the new language. There was nothing here. It was good government language. It was read several times to the Senate. It was voted, and it was voted without any dissent. All those record books are there. So it was the legislative intent in passing this law and creating these 19 forms of identification that county clerks can look at with respect to issuing a marriage license. And one of those 19 includes for the first time in our legislative statutory code that sex change and proof of sex change can be used for the purposes of marriage. The statute in 2009 clearly trumps a case law from a lower level appellate court in 1999. It's just done. The legislature did it. So if anybody wants to appeal it, they're going to have to appeal a statute that the legislative history is very clear. They knew exactly what they were voting on, and that it was a good government bill. So we feel that the law is very much on our side. On September the 2nd, 2009, she and Thomas had a legal, informal marriage up until the day that he was taken from her in July of 2010. They did not have a same-sex marriage. So that's the way it is. I just want to make sure that everybody understands, and Deborah, I hope I didn't jump on you because that wasn't my intent. But this is not some big legal battle, first impression, all this other stuff.
I don't think you jumped on it.
Okay, good. Before the legislature spoke in 2009, make no doubt, this would have been an uphill battle. I've been developing for years and years and years all kinds of ways to discredit Littleton, and there are many ways to discredit Littleton. But then the legislature spoke in the 2009 session, and the law became law on September the 1st of 2009. Littleton is a 1999 case out of the Fourth Appellate Court, Texas, which is in San Antonio. There are 14 appellate districts throughout the state. So this is a 10-year-old case by one intermediate appellate court down in San Antonio dealing with conditions that were the way they were in 1999. The legislature in 2010 said sex change can now be used for the purposes of marriage. Littleton just is not even relevant anymore by operation of statute.
But is that grandfathered law, the fact that the marriage occurred prior to change in the law? Does that, in other words...
There you go. Well, that's a good question. That's a very good question. That's why we have put into our pages that you have in our answer that beginning on September the 2nd of 2009, she and Thomas met the 3 conditions of an informal marriage. And these are statutory conditions. One is that they made an agreement to be married. Okay, any couple that is in love, as they were, and that live together as they did, they make that agreement almost every day. That they are going to be married and remain married. And she and Thomas made that agreement all the time. Okay, so that's one. Second is they have to live together in the state of Texas. They clearly did. The third is that they have to continue to hold themselves out as being a married couple. And from September 2nd, 2009, to their bankers, to their neighbors, to their friends, to their church, to their mechanic, to everybody that we've listed in our papers, they held themselves out. So there is no doubt that from September the 2nd, 2009, they had a legal, informal marriage until the day he was taken. So that's it.
Could I ask you one thing? It just occurred to me. That
yes, ma'am.
This is probably, for Nikki, this is probably 1 month anniversary of the thing going on. I mean, is it getting any easier? Is it more difficult? Is this just a living nightmare?
It is a living nightmare, and it's not getting any easier. No. Every day I miss my best friend, and